passing 5805, paragraph 73. This is Palmer's text a few days after the event. Between me and you, the recipient's not identified, we chop up de boy lizard, that's the deceased's nickname. Fine, fine, and dashing we enough. As long as you live, dem can never find him. Oh, couldn't be clearer. But the whole picture couldn't be clearer. And then we have also from JS2, I'm just going to give you the references. We have the texts between the deceased and his girlfriend, in particular on the 16th of August 2011. They are summarised at E4788 to 4791. And you can also see a short summary at in our written case, at 6227.
Can you just give those references again?
Of course. Yep. 4788.
Yes, thank you.
4791. And in our case, they're summarised again at 6227, paras 40 to 41. But those texts show without a shadow of doubt that the deceased was on his way to be executed, and he suddenly realised what was going to happen to him. There can't be any doubt about that. There are some texts also from Palmer. They were of no significance, but there were texts from Sean Campbell, which to an extent were incriminating, which suggested that on the day of the killing, but before the killing, Campbell said, who thief it, I go dead. That's say, whoever stole it is a dead man. And then after the event. But the references, you can see those texts at 4989, lines 1 to 14. And 4990, 13 to 4991. So they're plainly incriminating. Now, the defence cases, and it's important to understand what the defence cases were, they all just gave unsworn statements. Palmer's case was simply that he had never met Lizard at the premises on the day in question. And, my lords, that is at 4341. I should emphasise this. The SFI says that Palmer says he wasn't at the premises. That wasn't actually what he said. He said, I didn't meet Palmer. I never met Lizard at the premises. Rather different. So he doesn't give an alibi. The important point is he doesn't say, oh, I was at a concert or whatever, somewhere in Kingston. No alibi. Campbell, in his unsworn statement, accepted that he drove, he says, ahead of the deceased and Chow in another car to the premises, but he says the deceased got out before getting to those premises. And when Campbell got there, when Campbell got to the premises in question, he says he left Chow there. In other words, Chow did go there, but Campbell says he then left. And later, he saw that Chow, later that evening, he said the only thing Chow mentioned was that Palmer had received a dog bite and had to be taken to hospital. That's 4383 to 4386. Jones's defence was a very short statement. He just said the police were lying about him. That's 6137 at 16, or that's the, I think, of the SFI, and in the record, 4387 to 8. And St John said he left the premises just as Chow entered, and he saw Palmer getting bitten by a dog. And that's 4390 to 4392. The short point is that there was no denial, as far as one could take out, that they were there. And that is significant because the premises are then subsequently destroyed a few days later, or partly destroyed. And there's no explanation for this. Now, as to the exhibits, X14C, Exhibit 14C and JS2, their cases were simply this. The police have fabricated them. There's just a giant conspiracy to fabricate a whole mass of evidence. And there were challenges to the chain of integrity that went to that. That was it. But there was no explanation as to why the police should have done any of this at all. Now, my lords, bearing all that in mind, we say this was an overwhelming case where, for some reason, the only real question was, were the police in some way motivated, or did they fabricate all this evidence? That was the question for the jury. And, my lords, my lady, I respectfully submit there was nothing to support that. It's difficult to see, therefore, in those circumstances, why the alleged, or rather what you might call the bribery, would have made any difference to the consideration of their verdict. And I do submit the strength of a prosecution case in circumstances like this is a material factor. When one is asking, the question is there a risk, a real risk, that the verdict was influenced by prejudice? And I say, no, there's no real risk of that. My lords, my ladies, as far as the jury retirement point is concerned, that's what we say. So we say there was a fair trial, and the fundamental point is you can be satisfied that that 10-1 verdict was a verdict given by the jurors, or the 10, in accordance with their oath, uninfluenced by bias and prejudice. And if that's right, I submit the appeal must be dismissed. The next question I can deal with very briefly is the jury retirement point. My lords, my lady, I submit the following very short points. At the time, that's in 2011, there was no established practice written in a bench book or anything like that. The matter was left to the judge's judgment as to when to send the jury out. Second, I am informed by the Director of Public Prosecutions, who was here, who can provide more detail on the point. In real life, juries never take more than about a couple of hours or so to come up with their verdicts, even after long trials. And it is unheard of for them ever to have to be sequestered in a hotel room overnight. It just doesn't happen. Thirdly, there was, in my submission, no pressure applied by the judge in his directions. This is not a case where there was something the judge said at some point which suggested to the jury, you better get on with it. Far from it. There's at no point anything which the judge says to the effect, I do want you to come back in an hour or so, or please make your minds up, and so forth. So, nothing at all. No criticism of what the judge actually says. And finally, and I submit importantly, the Court of Appeal, who know all about this, how the system works, saw nothing wrong in what had happened. And if I can give you the reference, it's E5854, paragraphs 203 to 205, where they go through some of the cases about sending juries out in different jurisdictions, and then again at 209, where they come up with... 5854. Paragraphs 203 to 205, where they discuss the background and various other cases, and 209. And they discuss one or two Privy Council cases where juries have been sent out actually rather later, but although the Privy Council has disapproved of that, nonetheless the convictions were upheld. But in my submission, the Court of Appeal was perfectly entitled to come up with the conclusion they did. No error of law has been identified in anything the Court of Appeal said, and I submit it's not right, it's not the board's place to interfere with the Court of Appeal's judgment on these matters. Very briefly, the proviso, in one sense, my point on the proviso is this. Even if, let us say, the judge's directions after the jury incident were not as strong as they could have been, or should have been, or even if the retirement was too late in the day, there is still no reason to suspect that the jury was infected by bias or the risk of bias, given all the matters I have said. That being so, even if there was some irregularity or some imperfection in the way the trial was conducted, this is a case where there has been no, to use the words of the statute, no substantial miscarriage of justice. I should emphasise that I accept that if there was a risk of bias, a real risk of bias in the verdict, that would mean the trial was unfair, and that would also mean that you couldn't apply the proviso. An unfair trial is written water. But if the trial was fair, in my submission, you apply the proviso.
Do we have the statutory provision that contains the proviso?
I think we do. Yeah. In the bundle. For some reason, I seem to remember reading it recently. If I'm wrong, I'll be corrected. Perhaps I can...
Perhaps you could have the reference later.
I'll give you the references if I can find it.
Thank you very much.
My lords, my lady, that is only one point.
Yes, I think it's page 6806.
Thank you.
I think it's in the standard form of wording you're probably familiar with from other jurisdictions.
Well, I have noticed that they vary on
Well, the one we've been given
that's why I asked.
is the Judicature Appellate Jurisdiction Act, and it's section 14, the proviso to section 14.1.
Thank you.
No substantial miscarriage of justice test.
Yes.
And that's why I say there is, subject to the unfair trial point, subject to the unfair trial point, there's no unfair trial, the proviso I submit applies. The final question is that of remission. In my submission, this could hardly be a more serious case. It is of particular concern that we are talking here about great celebrities. That doesn't mean that you apply a different standard, but of course it does mean, in my respectful submission, such a high-profile case with, on the face of it, such overwhelming evidence. Most of it, of course, not the entirety of it, being of a technical nature and so forth. I submit this would be an appropriate case for the matter to be remitted for a retrial. My lords, I don't think on the whole you yourselves do that. You normally send it back to the Court of Appeal to consider. But I would submit there's every reason, if I'm wrong, for the Court of Appeal to consider what to do. My lords, those are my submissions on the main point. I've only got a little bit of time on the other points. I think I'm right to say my lords, you have seen our written case.
Yeah, this is the JS2.
Yes, the JS2 point.
Do you want to hear him on it? Or do you want to go off the bench?